in. Welcome everybody to our program this afternoon on climate change returns to the Supreme Court, the issues and stakes in West Virginia versus Environmental Protection Agency, which, as you all know, is the potentially landmark case the Supreme Court will be hearing next Monday. This event is sponsored by the Coleman P. Burke Center for Environmental Law here at the Case Western Reserve University School of Law. Just a quick note about the center. It was launched in 2019 with a $10 million endowment gift from our alum, the late Coley Burke, who was class of 1970. The center sponsors student scholarships, experiential opportunities for students, research colloquia, and webinars like this one. And we've had prior webinars on ESG reporting, on climate adaptation, on wildlife conservation, on Massachusetts versus EPA, and a wide range of other subjects. And on Friday, April 8th, we are sponsoring a full day in-person symposium on the Clean Water Act at 50 that will also be webcast live. Information about that is on the law school website. For today's program, we are offering or can offer 1 hour of CLE credit, and the CLE information will be provided at the end of the program. And speaking of the program, I'm excited today to have with us Professor James Coleman and Lisa Heinzerling to preview what is certainly the most important environmental case of this term, but a case that could easily be the most important environmental case of this decade, if not the 21st century thus far, in which the court has been asked to decide the scope of the Environmental Protection Agency's authority to control greenhouse gas emissions from the power sector under the Clean Air Act. As I mentioned, with me to discuss this case and the legal issues involved and the broader implications are Lisa Heinzerling, who is the Justice William J. Brennan Jr. Professor of Law at the Georgetown University Law Center, and James Coleman, who is the Roger G. Story Distinguished Faculty Fellow and Professor of Law at the SMU Dedman School of Law. So I'm pleased that they are here to join us, and I'm going to moderate a brief discussion with them, and then we will open it up to questions. Just to start, I guess, in order to understand this case, I think we have to understand a little bit of how we got there, right? This case didn't just suddenly spring up. We know a little bit about how the EPA began regulating greenhouse gases in the first place. Lisa, you were involved in this litigation. You wrote, even though I was on the other side, you wrote what was a truly tremendous brief on behalf of the Commonwealth of Massachusetts in Massachusetts versus EPA. Can you tell us a little bit about how the EPA came to begin regulating greenhouse gas emissions and how that led to the authority to regulate greenhouse gases from Section 111?
Yeah, sure. So just to back up just a bit even more, the EPA was petitioned by citizen groups to regulate greenhouse gases from automobiles. And the EPA several years later declined. They said, no, we don't have the legal authority to regulate greenhouse gases from under the Clean Air Act. And even if we did, wouldn't do it because of various policy reasons that we think make the Clean Air Act an unsuitable kind of mechanism for regulating greenhouse gases. And that's the decision that the Supreme Court rejected in Massachusetts versus EPA. It said, EPA does have the authority under the Clean Air Act to regulate greenhouse gases, and that it can't refuse to regulate based on policy reasons that aren't present in the statute. And so that then led to the agency eventually, early in the Obama administration, declaring that greenhouse gases endanger public health and welfare. That is the consistent trigger for regulation throughout the Clean Air Act. Air pollutant endangers public health or welfare, then generally that triggers regulation. And so not only did the EPA then have an obligation to regulate greenhouse gases from motor vehicles, but it also then had an obligation, in my view at least, to regulate under Section 111, which is the section at issue in the case we're talking about today. And that it couldn't very well say, having found that greenhouse gases endanger public health and welfare when they come from automobiles, couldn't very well turn around and say they don't endanger humans when they come from power plants. And so EPA made that finding and set on a path to regulate greenhouse gases from power plants under Section 111. And it set standards for new sources and for existing sources. And for existing sources included not only measures in trying to figure out what goals should the states be required to meet in reducing emissions from existing sources. The agency considered not only stuff you can do right at the power plant, the individual power plant, like improve efficiency, but also things that the source could arrange for, reductions they could arrange for through, let's say, buying credits, emission credits from other plants. So that brings us up to it. It really sort of was set off by the decision in Massachusetts versus EPA, leading to the endangerment finding, leading to an obligation to regulate under other programs.
Okay, great. And so under that authority, with that understanding of its obligation, the EPA adopted the Clean Power Plan back in the Obama administration. James, as is common with environmental regulations, especially these days, major regulation gets promulgated, folks run to court and challenge it. Can you tell us a little bit about kind of what happened when coal producers and red states went to or challenged the Clean Power Plan, and kind of what happened also when administrations changed and we now had an EPA that had a very different view of what sort of approach we should take to greenhouse gas emissions from power plants?
Yeah, absolutely. And thanks so much, Jonathan and Lisa. It's so wonderful to be here. This, I mean, obviously just a blockbuster case, and it's very, will be fascinating to see what happens. So exactly as Lisa said, the Clean Power Plan sort of went beyond this idea of actually making the source more efficient. And it included that. It had 3 building blocks, right? It said, first, we're going to make the source more efficient. Second, and the second and third steps really related to, sometimes maybe the most efficient way to reduce pollution from a source is not to run it at all, right? And so the idea was that instead of running these existing coal power plants, you could instead use natural gas fired power plants instead to meet electricity needs. And so that was sort of that building block 2. And then building block 3, that you could use those renewable energy sources and other zero carbon sources to meet it. And so that that received a challenge. And one thing that you saw develop over the course of the Obama administration and now going forward is that challengers were particularly worried about the risk that they were going to have to comply with the regulation before they ever got a decision from the courts, and especially the Supreme Court, on its validity. And that was in some ways heightened because there had been a previous rule during the Obama administration, a rule limiting mercury from coal-fired power plants that was ultimately overturned in the Supreme Court. But the EPA said, well, no worries that our rule was overturned because a lot of power plants are already meeting that because they knew they had to comply with that. And I think so for that reason, you saw power plants sort of trying to get this challenge as early as possible. And there was actually a challenge that went in, I think, on the proposal of the Clean Power Plan as well, that was rejected by the courts. But when states and the coal industry and other interests challenged the Clean Power Plan, they asked for a stay of the regulation while it was being challenged in the court. They asked for that from the DC Circuit and it was not granted. And then they asked for that from the Supreme Court as well. And it was granted. It was granted February 9th, 2016. It was a 5-4 decision. It was, this is a very unprecedented event that the Supreme Court would step in to stop a regulation before it had even, the circuit court had even heard about it. But because it's that, shadow docket action, or it's not on the regular docket, that means that we didn't get an opinion. It's just a 5-4 decision. And that was in fact the last vote, at least that we're aware of, that Justice Scalia made before he passed away. And so that was, it was obviously a very big vote because it meant that the Clean Power Plan would not go into effect until there was a decision on the validity of the regulation. Now, in the meantime, that case had to go forward. And so it was argued in the DC Circuit. There was for the first time this happened on this set of rules, there was more than 7 hours of argument in front of an en banc DC circuit. That was in the fall of 2016, when nobody knew who the president would be for the next term. It was in September 2016. There was an argument on the validity of the Clean Power Plan. I think court watchers think likely the en banc DC circuit would have said, in fact, it was legally valid, but we never got a decision because instead the Trump was elected. And when that administration came in, made very clear it was going to repeal the rule, and it eventually did so, and replaced it with what it called the Affordable Clean Energy Rule, or the ACE rule, or ACER. And the idea of that rule was that instead it would limit itself to those heat rate improvements, basically things to make the power plant itself run more efficiently, rather than to run the power plant less. And so, and it said that, in fact, the Clean Power Plan was that the Obama administration had adopted was not legal under the Clean Air Act, and that they were compelled by the text of the Clean Air Act to limit themselves to improvements at the source. So sometimes there's a lot of different ways people talk about this. Is it just that building block one, i.e. just heat rate improvements and efficiency improvements at the source? Or do you go beyond the fence line, in other words, to other parts of the power system to try and run cleaner sources rather than coal power plant and dirtier sources? In theory, efficiency improvements at the coal power plants should reduce emissions, but there are also some who express concern that maybe by making them more efficient, they might run more often, and you might even have more emissions. So it's unquestionably would have led it to lower emissions reductions than the Clean Power Plan, and for that reason, it was that itself was challenged. I think at that point, I'll turn it over.
Well, great. Yes, thank you. Thank you for that. Yeah, so Lisa, as James just mentioned, and as we've come to expect, the Trump administration dramatically reverses course on not mere, and I think this is important for viewers to be sure they understand, not merely on the policy, but also on the interpretation of the degree of authority that the EPA had, and use that as the basis for we could say stingier a rule under Section 111 than the Obama administration had put forward. That gets challenged. Big opinion from the DC Circuit issued, I guess, the last day or the penultimate day of the Trump administration. This is the opinion under review by the Supreme Court now. What are the key elements of what the DC Circuit said about the Trump rule, and what was wrong with both that rule and the rescission of the Clean Power Plan?
Well, it's really important to emphasize, I know we've already just heard this, but just to say it again, that the Trump administration had one reason for repealing the Clean Power Plan and replacing it with a much weaker rule. And the reason was that it thought that the Clean Air Act clearly prohibited EPA from basing its emission guidelines for existing plants on anything other than those controls right at the source, right at the physical power plant. That's the only reason they gave. Why is that important? Because a basic principle of administrative law is that agencies have to explain their reasons for doing what they do, and they have to explain them at the time of their decision. So courts have long said, for many, many years, have said, it's a principle called the Chenery Principle. And the idea is that the agency has to explain itself at the time it makes a decision, and a court will not affirm an agency choice if the reasons the agency gave at the time of the decision are important. This turned out to be really critical for the DC Circuit's opinion, which in a sense is actually quite narrow. And so what the DC Circuit said is, you were wrong, EPA. That was an incorrect legal premise for your repeal of the Clean Power Plan and your replacement of it with the weaker ACE rule. You actually are not clearly forbidden by the Clean Air Act to include those so-called beyond the fence line measures. And then the court sent the matter back to the agency because the court said it may well be, once you have this appropriate understanding of your authority and understand that you are not limited in the way you thought under the statute, then you can go and decide what you want to do with the authority that you have. And we're not saying that it would be reasonable to interpret the statute in the same way the Clean Power Plan did. We're not trying to prejudge that. We're letting you, the agency, write a new rule based on a correct legal understanding. And so that's the way that the rule went back to the agency was with that understanding. And I'm not going to go into all the ins and outs of the opinion. I will say, and I know that you all might disagree with me, I think it's a thing of beauty in terms of statutory interpretation. That opinion is written so carefully, so thoughtfully, and shows us what statutory interpretation could look like if we stopped insisting on just looking at, often taking a complex statute and narrowing it down to a single word and not looking at anything else, not looking at anything about what Congress was trying to do. This was, in my opinion, a masterpiece of legal reasoning of a very kind of, at this point, sadly old-fashioned kind.
Thank you for that. And James, as again, we come to expect, no one takes a adverse decision and lets it sit. Red states and coal companies filed petitions for certiorari. I think most observers were surprised that the court granted cert. I guess, James, were you surprised that they granted cert? And could you just tell us, I guess, briefly, what the petitions asked for? Because there were a lot of issues involved in the case in the DC Circuit opinion. What are the issues that the petitioners have asked the Supreme Court to decide in the case now?
Right. So, it's yes, I was surprised. I shared most people, and just to be, and the reason it's surprising really builds on a little bit of what Lisa said, is that so this opinion didn't tell EPA what to adopt necessarily, and so then the question is, what is really being challenged in the decision below by the industry, right? And I think the answer is they're challenging both it invalidated, of course, the Trump administration rule for exactly the reason Lisa mentioned, which is that it says the reasoning that was used to adopt it was mistaken, but it also invalidated the repeal of the Clean Power Plan, right? So, in theory, that means, the Clean Power Plan would be binding. Now, there's two problems with that, as, if that's what you're challenging, the Clean Power Plan being in effect. One is that the court stated its mandate on that, right? Now, that's an indefinite stay. Maybe that's going to the sort of Damocles. You're worried about that. On the other hand, the Clean Power Plan was promulgated at a time when we didn't know how rapid progress we were going to make on decarbonization as a result of using less coal, more natural gas, and more renewables. Renewables for the first time last year passed coal as a source of power. And so we've actually made, in many parts of the country, just, as much progress as was mandated under that rule. Now, with all that said, maybe that's still enough of a challenge for, our Article 3 standing purposes. There's a good article out either today or yesterday by Ricky Revesz arguing that this is effectively the challengers here are asking for an advisory opinion, and I recommend you read that. But it seems like there's like a nub of a challenge, which is, well, the Clean Power Plan, in theory, the repeal was invalidated. In theory, that may still have something to it for some of the challengers. But the question then becomes one of, practically, why would the Supreme Court, if there's not a lot at stake in this issue, and the Biden administration has said it doesn't intend to adopt the Clean Power Plan, to re-adopt that, how is this an important enough issue for the Supreme Court to take? And so I think that's the reason most people were surprised by it. It's the reason I was surprised by it. With that, I will say, one thing that we're seeing with the shadow docket and others is that the Supreme Court is a little bit increasingly wary of the notion that a lot can get decided in the industry without them ever having an opportunity to discuss it. And so those EPA actions, long before they get to it, have determinative impacts on investment in the industry. I think they're sensitive to that kind of claim, which is the same reason that you had the vote to stay the Clean Power Plan. So it didn't shock me, but it did surprise me. So yeah, now the issues, there were several potential issues here, including whether you could even regulate greenhouse gases under Section 111D, the issue here, but the court instead took the issue of whether EPA could go beyond the fence line. In other words, whether it could apply as the Clean Power Plan did, and as the DC Circuit determined EPA could do, could it go beyond the fence line to consider emissions beyond the fence line? And also, to what extent that requires EPA to resolve major questions, i.e. questions of vast economic and political significance, which has been an issue in a number of recent Supreme Court cases, a lot in academia. I know Lisa and Jonathan, and not me, have both written recently on this topic, but it's a very, very important, and pretty much all of your law professors are interested in it for that reason.
Great. Thank you. Lisa, James mentioned there is this question about, is there a case? And I guess there's two parts to that, and I'd love to get your thoughts on both. One is a claim made by the Solicitor General, and I think at least one of the respondents' briefs, other respondents' briefs, that there's no case or controversy, that the court, if it looks closely enough, would determine there's no Article 3 standing, and therefore no case for them to resolve. And then there's this kind of subsidiary claim that, well, maybe there's jurisdiction, but as a prudential matter or perhaps on mootness grounds, the court should nonetheless just simply vacate the lower court opinion and dismiss and basically say to EPA, the field is clear. I was curious as to your assessment of both of those arguments that are advanced by the federal government and the other respondents.
Yeah, I, like everybody else should have, I have a little bit of trouble distinguishing sometime finally between those different justiciability doctrines. I love the DC Circuit panel opinion with 3 judges offering 3 different reasons why the case was not justiciable. That's a little the way I feel a lot of times. And so, but this case doesn't feel like it fits. No matter where I look, whether I look to standing or ripeness or mootness, there is no rule in effect right now. There's just no rule in effect. And so the ACE rule is not in effect. The Clean Power Plan is not in effect. The vacature of that has been stayed. We're at a moment where nobody has to do anything because of EPA's actions. There's just nothing in front of the court. And so it strikes me that that's just not the kind of case that fits into either the non-prudential, the ones where the Supreme Court says, oh, we have an obligation in every case to decide on our own whether we have jurisdiction. Well, where'd that go here, right? Where did that go? They were asked even to add a question on standing and justiciability, and they didn't. And so it just seems very curious to me that they've accepted a case in this posture where nobody's required to do anything at the moment. And I understand what James is saying about people feeling compelled to act on the basis of future rulemakings, but how far does that go? Even Judge Kavanaugh in this case said you can't challenge a proposed rule. We don't even have a proposed rule here. And so it just feels like it doesn't fit. I guess for me, what it feels most is like mootness, where it comes to the court and in a way it is mooted basically the day that decision was issued. The next day, Biden comes into office and says, I'm looking at this. And so in that situation, I think the appropriate course is for the court either to dig it, to dismiss the case as improvidently granted, say, you know what, we just don't think there's a reason to review this, or to vacate the decision below and be on grounds of mootness. But it just doesn't feel to me like there's much of a case. I'll also say, and this I think goes to the prudential matter more than the constitutional matter, but the government has come to the court and said, we don't have any plans to reissue the Clean Power Plan. We are thinking about it. We're thinking about it in light of everything, including this court stay, which, by the way, as James pointed out, didn't deign to give us an explanation of why the court was, for the first time, staying an agency rule directly without any judicial review below. And so there's a way in which there's a lot of distrust that I'm feeling coming from the Supreme Court towards the agency. When presidents come into office, new presidents come into office frequently, the administration will ask the courts not to decide questions that they're going to come and revisit, right? Please don't decide that case. We are revisiting this issue. Those are frequently granted, those kinds of motions. And here the Supreme Court is just really wading in at this very, it seems to me, awkward moment. And it feels like they're kind of kids in a candy shop at this point. They have their 6 justice majority. They've been itching to take this case since February of 2016. It's been on their radar. They issued that extraordinary order in the Clean Power case saying this rule is stayed directly until we decide whether we want to review it, right? And so it just feels very willful, very aggressive to me that they took this case at all.
James, I don't know if you have any additional thoughts on the just jurisdictional or justiciability questions, but I also wanted to get into the major questions doctrine. And I should just say, mentioning questions, if you have questions for either of our speakers, please put them in the Q&A box at the bottom of your screen, and we will be getting to questions shortly. But it seems that one of there's the narrow statutory interpretation question, right? What does Section 111 mean, or Section 7411, depending on which ordinal system you like. But there's the technical statutory interpretation question, and then there's this major questions overhang. This idea that either the court should not defer to an agency's interpretation of a statute where that interpretation implicates a quote unquote major question, a question of broad economic or political significance, or I guess the more aggressive version of that, which certainly some of the petitioners seem interested in, which is the idea that if in fact the major question is the agency's authority to do something of broad economic and political significance, there should actually be a thumb on the scale against finding that authority to exist, or against finding that delegation to have occurred. Could you kind of just unpack for us a little bit the nature of or kind of what those arguments look like as applied to Section 111 and EPA's authority to regulate greenhouse gas emissions from power plants?
Okay, great. I think that question itself unpacked things a fair amount, which is, as I said, we have the authors on these topics right here. But yeah, so the major questions doctrine says that the court's going to hesitate before concluding that Congress intended to give the agency the authority to regulate as it likes to areas of vast economic and political significance. Now, that's what they've said. There's been a number of cases in which they've talked about it. I think sometimes as we think about it currently, and as it just sounds, it sounds like there's like a little bit of a deregulatory impulse behind it. Like who would let the agency decide these important questions? I do think it's important to note, though, that in its development, a couple of the most important cases in which this development were cases that sort of expanded government authority. So one is the MCI versus AT&T telecom deregulation case, where the court basically said, Congress, it said, no, you have to continue regulating telecom, you can't just pursue a deregulatory agenda based on your, authority to regulate telecom. That doesn't include the authority to just get rid of regulation in this area. And the area where it was probably most clearly stated recently was King versus Burwell, a case upholding the Affordable Care Act. So it's not, it doesn't always have that, but there are that valence where it's always anti-regulatory. With that said, it really there are two ways of thinking about it. And one is maybe more anti-regulatory. So one says, what does Congress mean? We're interested in what Congress meant, and we're not going to assume that it's sort of related to this elephants and mouse holes principle. We're not going to assume that Congress hid some vast authority in a tiny corner of the statute that maybe they didn't even read carefully, that is going to allow the agency to completely change it, because they probably didn't mean something if they did that, just on the sort of on the side. And there's, there's interesting questions about intent, because maybe literally that is what it means, and should we follow the literal intent, and why is the intent relevant if things have changed that made that corner of the statute very important? Just like a part of a contract you didn't think about could become very important, like a force majeure clause, if something really strange happens. So it's kind of interesting questions about what intent means if you follow that line of cases. There's the other way of thinking about it, which says, we just don't believe that Congress should be allowed to delegate major questions. And so, or at least as a matter of constitutional avoidance, we're going to, unless Congress is really clear, we're not going to consider them to have delegated that big question, because otherwise we might run up against the limits of the non-delegation doctrine, if that still exists, or to whatever extent that exists. And obviously, I think that part of it has certainly a more deregulatory aspect, because the non-delegation doctrine has always been kind of a specter haunting administrative law at various times. We thought maybe it's going to come back, and then it's kind of been beaten back with Whitman or not any number of cases. And if I'm reading, Lisa, some of the things that you've written recently, I know that's something you're in particular concerned about, and that Justice Gorsuch has indicated he might be interested in. So I think those are, that's the kind of question that's at issue here. Now, in terms of how it applies to the case, personally, for me, the strongest aspect here is the intent, using the major question doctrine and intent, because one of the issues that the court didn't take, but is kind of an interesting issue about Section 111, is that Section 111D, which is being used for this regulation that, as it turns out, the Clean Power Plan itself wouldn't have changed things that much, but the mechanism that it devised, i.e., you should, basically run these power plants less and run a different kind, is potentially transformative for the industry, depending on how aggressively it was pursued. And the mechanism that was used for that was Section 111D. Okay, well, what does Section 111D say? Well, it's really it's a sort of small part of the Clean Air Act, which often focuses on new sources, that applies to existing sources and allows EPA to adopt guidelines so that the states can adopt some kind of controls for those sources that otherwise sort of slip through the net, those grandfathering or existed sources that aren't covered by most of the rules in the Clean Air Act. Now, this part of the Clean Air Act, one of the legal controversies is that there's actually two versions. So there is a House version and a Senate version of this section of the Clean Air Act. And under one, you would be able to regulate greenhouse gases. Under the other, you would not be able to. And I do think maybe if this is a section of the Clean Air Act so obscure that Congress couldn't even be bothered to see whether it was passing the same version before the president signed it, that maybe there is some implication that they probably didn't intend to allow major changes, to give the power to force major changes of the industry through this section, just as sort of, if you told your friend to grab you something at the grocery store, you said, could you get, bread and milk and, anything that looks like it's a good deal. If they came home with patio furniture, sometimes they do sell that at the grocery store, but you might just say, well, that was kind of a big decision. even though, yes, I guess technically it was something on sale. So there's this kind of intent issue at the background that I find convincing in this section. I'm not convinced by the non-delegation doctrine aspect of it, but it's important to see those two. And really everybody, I mean, this is important for vaccine mandates. This is important for so many regulatory questions. And this is the one that if your ad law prof is following this closely, and this is why. Major questions.
Okay, Lisa, you've just heard the kind of the perhaps one of the stronger ways of framing the way major questions might apply here. I'm quite confident you disagree with it, but so tell our viewers, what is the counter argument to this idea that what EPA would perhaps want to do or did in the Clean Power Plan, and what the DC Circuit seemed to validate, is using this small, perhaps relatively obscure, not particularly well focused upon provision of the Clean Air Act to do something that, however worthwhile, seems like a heavy lift from a small obscure provision. What's the counter argument to that?
Okay, and then I'd also like to talk just a little bit about major questions in general.
Yes, please.
Yeah, so on that counter argument, I don't understand this argument at all. How do we know what's an ancillary provision and what's not an ancillary provision in an incredibly complicated statute that runs to hundreds of pages? What do we know about that? I don't even know what that means. What's the test for that? What's the test for a provision that's too old? The Supreme Court itself was created under a statute in 1789. Right? There's a way in which it's just mind-boggling to me that we're at the point where we're saying, well, EPA can't address climate change from a source of 30% of the emissions of greenhouse gases in this country, can't address it in the most effective way it finds because it's in too small of a provision. Well, that just is to beg the question. It's a small provision if you don't interpret it the way that the EPA interprets it. So it just feels so strange to me to be making those kinds of arguments. And I understand, James, that's not all you were saying by any means. But then you did go on and talk about intent. And here, I guess I have to differ. I've never thought major questions was a way of looking at actual congressional intent. The Supreme Court has been out of the business of caring about actual congressional intent for some time. As Justice Kagan says, we're all textualists now. They don't care about purpose. They don't care about intent. To me, what they did was they invented an assumption about the way Congress passes legislation on major questions and then held Congress to acting that way. So they say, we expect Congress to speak more clearly in these matters, or we don't think Congress would hide an important provision in this kind of ancillary section of the statute. That Congress does that all the time. And it just invented that assumption about the way Congress decides things. I think the assumption is false. And I also think that the Supreme Court actually doesn't care about intent. I think the Supreme Court actually has gotten, in the major questions evolution, has gotten more and more scolding to the point where it seems quite plain to me that what they're creating is a really strong, clear statement principle. They're saying, which is invented by the court, they're saying you need to be clear if you want to give an agency that kind of power. Nothing to do with intent, nothing to do with the way Congress actually operates, just a kind of, in my view, a position against a certain kind of regulation. And let me just turn then to some basic problems I find with the major questions doctrine. One is just obvious subjectivity. So we're going to rely on 6 justices to tell us what policy questions are important, what's politically and economically significant. And we think they know. We think they know when they don't develop a record in the Supreme Court. They have no fact-finding capacity. What are they going to do? They're going to do what they've done in the past cases very recently. They're just going to kind of look at the situation quickly with a certain idea in mind and conclude it offers a major question, and that means the regulation is done. There's very little other than, I think, a kind of an impulse kind of almost a physical reaction when they read about the rule. And that just seems like not a good basis for statutory decision making, not respectful of Congress. The other thing about it that I think must be said, and I understand what you're saying, James, about some of the other cases, but I think the major questions doctrine at this point is plainly a one-way ratchet against ambitious regulation. How do I think that? Well, in Massachusetts versus EPA, 4 justices dissented. They would have deferred under the Chevron principle to EPA's statement that it didn't have authority to regulate under the Clean Air Act, and it wouldn't anyway, even if it did. And Justice Scalia thought that was just absolutely a Chevron case. He comes around to the Utility Air Regulatory Group case. He says, oh, no, we're not going to defer to EPA's judgment about whether to regulate these greenhouse gases. What's different about those 2 cases? The first, EPA didn't want to do anything about climate change, and the second, it did. That just seems to me to be just, for me anyway, and you tell me where I'm wrong, plain as day, askew in the doctrine as it's developed, that an agency that acts ambitiously is going to get in trouble, an agency that sits on its hands is not. And here's the weird thing, to me, that skew not only is politically problematic, right, for a court, but it also makes the doctrine, in my view, just nonsensical. That if an agency deciding to regulate or not to regulate is answering the same question. It's just answering, in one case, we're going to regulate ambitiously, and the other one, maybe we won't regulate at all. But they involve the same economics, the same political context, the same statutory language, everything. It's just in one case, the answer is yes, in one case, it's no. So they are grappling with the very same facts on the ground, both political and economic. And so an agency doesn't avoid a major question by not acting on a problem. It just doesn't act on the problem.
Okay, James, turning to you, Lisa suggests this approach to statutory interpretation is perhaps a one-way ratchet, is perhaps deregulatory. I think it's fair to interject here that at least from what we've seen in recent opinions and some of the concurrences, especially the Gorsuch concurrence in the OSHA vaccinate or test emergency temporary standard case, that there are at least some justices that I think have openly embraced the idea of this as a deregulatory notion, in part because Justice Gorsuch has said he would like to revive the non-delegation doctrine. So I'm curious if you have thoughts on that. And then also, is this just about Section 111, and not to minimize Section 111 or the fact that 30% or so of greenhouse gas emissions come from the power sector, but is it just about what we do with this provision of the Clean Air Act, or do you see this how the court resolves this question as having broader implications for other areas of environmental law?
So let me say a couple of things. One is, well, I definitely agree with Lisa that it will, like most interpretive canons, be used politically to some extent. And and when I say I was not shocked about the Supreme Court taking this case, I mean, realistically, there is going to be some amount of conflict between a DC circuit that's one of the more liberal courts by nominee, by party of nomination, and more conservative, substantially more conservative Supreme Court. I think realistically that's part of what's going on here, and I do think it certainly is possible to interpret it that way, particularly if you decided, if you decide to regulate, then it's a major question, but otherwise not. Now, I would say, like in most of these things, I believe that the doctrine also has interpretive substance. I also don't think the Supreme Court completely doesn't care about intent. I think if you look at King versus Burwell and that Affordable Care Act case, a lot of that is driven by, come on, surely Congress didn't mean to run healthcare in this way. And so, and I do think that MCI decision is important. And sometimes as lawyers, we have to argue as though these doctrines are implied impartially, even though we don't know they may not always in fact be. However, in terms of its implications, to me, it clearly has the biggest implication. I mean, the implication if it's a question of interpretation, is mostly about more clarity in congressional legislation. Now, knowing how very difficult it is to pass legislation, that's very small comfort, right, for people looking for more regulation on certain topics. I think as all of us are. Then on the but on the other side, if it is deregulatory, I mean, I don't believe that the Supreme Court would go that way, and I would not favor that. But certainly, that would have much bigger impact, not just on environmental law, but in general, because there are so many areas of our administrative state where we basically authorize an agency, hey, you go figure out this area. I mean, that in some ways, the FCC is a great one. So, in any event, I just think, yeah, that could have big impacts if people went Justice Gorsuch's way on the major questions doctrine.
Lisa, did you want to add anything in terms of what the potential implications are of what you think are kind of reasonably likely possible resolutions of the case?
Yeah, I do worry about implications beyond the Clean Air Act. I do think the Clean Air Act itself is important given the moment we're in with respect to climate change, but even beyond that, we are already seeing in the last year a big bump up in case filings brought by people who have obviously noticed that the Supreme Court is enamored of the major questions idea. And so those litigants have been emboldened by the Supreme Court's just even suggestions about major questions. And then we're seeing district courts being emboldened as well, so that courts actually deciding quite oddly that cases raise major questions. And I know you two are familiar with this, the district court ruling that the social cost of carbon may not be discussed, right, in the federal government anymore because it raised a major question. And I think one of the dangers is that the major questions doctrine and the non-delegation doctrine, I think we will see them blended by Justice Gorsuch and maybe the whole court. But in any event, those two both are all-purpose kinds of arguments. They can apply to any statute, to any regulatory system. They're not context specific, and that makes them really dangerous. And I worry about litigants and district courts being emboldened. I worry about the Supreme Court. It loves its shadow docket. It can very quickly shut down a rule as it did the Clean Power Plan. I think it did that based on the major questions doctrine. If you look at the briefs on that stay, they were filled with major questions ideas. And so I worry that this will be, as I've put it in another context, they will aerosolize the major questions doctrine, not even just weaponize it, aerosolize it, the sense we will see it everywhere in filings. And unless the Supreme Court is prepared to really put a stop to that, which why would it if it gets that ball rolling, it worries me about the structure of government and the nature of public protections.
Now, we have a related question in the chat on this. I mean, is the way it appears the Supreme Court is applying the major questions doctrine, and perhaps could hear, essentially Congress, you must predict every problem that before you can address it. I mean, is that a fair? See Lisa nodding her head. Is that a fair characterization of what seems to be emerging when we look at the issue presented in this case against the background of, say, the CDC eviction moratorium decision and the OSHA ETS decision? I don't know if either of you have thoughts on that.
Yeah, I think, may I?
Yeah, please.
Yeah, I think so. I think that is a common thread. That's an excellent question and statement, because I think that is a common thread of these cases where Congress wrote with broad language, clearly aimed at a kind of problem, didn't foresee every way in which that problem would manifest. And the court is shutting that down. Oh, the statute's old. Oh, you haven't done this before. There's a very retrograde kind of, feeling to it. And so I think one of the things that's endangered is the ability of Congress to legislate broadly in anticipation of problems that it knows the general shape of, but it can't foresee in particulars.
James, do you have thoughts on that? Or anything you want to add?
I actually do agree. I mean, it's a challenge for sort of the new wine and old wineskins, way of addressing statutes. Now, I think that is, any number of us. I mean, it's interesting because Lisa earlier described the UARG as a case where there was a rejection of a decision to regulate, but in some ways, that was actually EPA at the time presented it as the most deregulatory action that had ever been taken. So, and it was a rejection of that because it said that, well, we don't think that Congress would just let you deregulate in this crazy way where you take a statute of 150 pounds or 250 pounds and make it 75,000 tons of carbon or whatever. The change was, and the reality is, yeah, when you have a very awkward fit between a new problem and an old statute, it doesn't always work well. And I think it would be better if we had new statutes. I think we all agree on that. But I do think, yes, it's a further thing that makes it difficult to try and find corners of old statutes to solve new problems that maybe are an awkward fit in those statutes.
Yeah, I can't help at this point note that I kind of a self promotion, I guess, that Chris Walker and I have this paper that, among other things, tries to explore some possibilities about how Congress could incentivize itself to revisit statutes on a more regular basis so as to avoid this concern about old delegations being repurposed for new problems. Congress hasn't taken our advice yet, but at least there are other academics out there as well trying to figure out, are there ways that the legislature could force itself to be more in the game to perhaps resolve some of these questions. Another question in the chat is, is there an opinion we can imagine that ends up resolving this case in a relatively narrow way, assuming the court still reaches the merits? Is there a path to a near miss, or is that fanciful thinking for folks that want EPA to be left with significant authority? Either one.
I actually think that's probably the most likely. And part of why I say that is, it appears to me, I could be wrong, that law professors are far more interested in the major questions doctrine, every species of Chevron, and all of this than the Supreme Court is. So my guess is, we get some cryptic language, and I don't think, unfortunately, I would love it to resolve and just say, oh, it's just an intent thing or whatever, but I don't think they'll do that. But I also don't imagine something that, if I had to guess, I don't see something, suggesting major questions is a much bigger deal, but I could be 100% wrong about it. So you can all remember I said this and make fun of me later. So I'm not anticipating necessarily a broad ruling. Now, I think the specific question was, could there be a narrow decision in favor of EPA on the basis of its, that really there was congressional intent here to attack wider problems, even through this provision? I personally think that's very unlikely. I think that's unlikely for several reasons. I mean, even Justice Roberts, who for sure you would need his vote, he was obviously he was in the dissent in Massachusetts versus EPA. If you look at the UARG case, one of the things it said was that there can't be a requirement that the source use less energy or basically have certain efficiency things. So anything that kind of looked a little bit unusual, they pretty much said shouldn't be applying. I think that is it doesn't seem that the Supreme Court believes this is how the Clean Air Act operates. So I think that's unlikely. So if I had to predict what would happen, my guess is a narrow ruling that goes against EPA.
So Lisa, James thinks we have a narrow ruling in store for us. Do you share that take or that sense of what is likely, or do you expect something much broader?
Well, I'm going to hold out hope against all reason that they'll see the light and say, you know what, we shouldn't decide this at this time. So that would be the least intrusive, obviously, way to go. If they turn to the statute, I'm afraid it's hard for me to see a way out. I suppose one possibility is they say the statute is ambiguous on the point that the court below thought it was not unambiguous and send it back to the agency to deal with that reality. I suppose that's the most narrow ruling I can think of, but why reach out to take this case now? Why reach out to do that? So I'm afraid, and also the decision doesn't have to come written as big historical decision. All they have to do, they did in the eviction case and in the vaccine or test case, they just refer to major questions, and that's enough to set the flocks of district judges to send them to their typewriters to strike down rules. So, as you know, decisions from the Supreme Court speak really loudly, even if they're written, seemingly humbly.
Well, one observation there, the one easy way of dealing with this case could be the court concluding that there's sufficient ambiguity in the statute that EPA has some wiggle room. Although, as I know, some admin law folks have pointed out, it's been quite some time since the majority of the Supreme Court has concluded that statutory language was ambiguous and got to step 2 of Chevron. And there's been lots of speculation about what that means. But if the court, resorted to step 2 of Chevron in this case, that in and of itself would be significant for administrative law. Another question in the chat, which is maybe a technical question, but I think it's actually an important one. And so when in applying Section 111D, there's kind of 2 things that the agency looks at. Right, one is, and I'm oversimplifying, so for those of you that are experts in this, I apologize. But on the one hand, the agency figures out what degree of emission reductions the best system of emission reduction can achieve as a way of setting the emission reductions that have to be met. And then there's a second question then of what can be done to get credit for those reductions. And we could certainly imagine a regulatory structure that doesn't treat those in the same way. That is to say, doesn't say consider fuel switching in setting the target, perhaps, but still gives folks credit for doing that if that's how they achieve the reductions. And obviously, there are folks on both sides of this case that want those 2 in tandem, right? That if you look at everything in setting the targets, you get lower targets. If you're coming from the coal industry, you don't want those factors considered in the targets, and you don't want them in compliance either, because you don't want there to be any incentive to shift away from coal. And I'm wondering if either of you have thoughts about whether or not this decision is likely to keep those 2 aspects wedded together, or whether or not it's reasonable to think the court might decouple them or bless the decoupling of them. And I hope that question was clear enough to go off of.
The main way I've seen that argument come in the briefs, and maybe I've missed something, is to say that this is an unusual regulation, indeed maybe unique regulation from EPA under Section 111, that the claim is made that the EPA has never approach the question you raised, Jonathan, in this way, so that in the Clean Air Mercury rule, the claim is that EPA didn't set the reduction target based on those trading and so forth, that just allowed that as a means of compliance. And so I just wonder whether that it's really in the case more as a way to hold that EPA's general interpretation is wrong, rather than a way to get a kind of narrower ruling. But I could be wrong. They could take that bait.
James, any thought on that point?
I think I doubt that the Supreme Court would get that in the weeds on whether you can do it for compliance, but not for setting the goals or otherwise. I mean, it's certainly it's something very important to the parties, but I don't see them getting involved in that, making that determination.
Okay, well, we are at the bottom of the hour, and there's a link for the CLE form in the chat. I'm about to show the information on the CLE. So a final question to each of you. It's different than what I said I was going to ask, but we've already kind of gotten your predictions. So the oral arguments on Monday, kind of if people are listening to the oral argument, what in your view is kind of the most important thing that people should be listening to? Like what is the thing that if it's raised, it would be most significant, or the sort of question you will be listening to most intently? And I'll start with you, James, and then Lisa, just kind of what should we listen for?
Well, I would say to start with any questions from Justice Barrett, and maybe maybe from Chief Justice Roberts as well, because you're looking for swing votes first. I think the other thing I would listen for is is there any interest in this idea that it's been mooted by the Biden administration's decision that they're not going to adopt something similar. If you look at the regulations that they proposed for oil and gas, existing oil and gas systems, that's I do think that is they don't follow this building block approach. It is more traditional approach to existing standards, and I think that would be maybe that's enough to convince the court that this isn't a big issue that they don't need to address. And then I would say just any engagement with the, in some ways, absurd reality of how long this case has been going on. I mean, this is all based on a 2010 settlement agreement that the Obama administration had with environmental groups that was for adopting existing source standards, I think both for EGUs, for electric generation, and for refineries. And we're so far I think, in my area, I deal a lot with our failure to build infrastructure in a timely fashion. But in the regulatory sphere, there's obviously a massive failure to make any regulatory progress on any question in a timely fashion. And it'll be interesting to see how that question, percolates before the court. I mean, certainly, we got a decision on the Trump, the Trump administration was, okay, we're going to do this from day one. We got a decision the last day of the Trump administration. And, how does any administration, sort of move the ball on this regulation that's been, promised for so long?
And Lisa, the last word goes to you. What should we be listening for? What are the tells or the warning signs or the red flags that folks should be listening for?
Yeah, I think one, when the petitioners, the people who are against EPA authority in this regard, when they stand up, if they're not asked immediately why they still have an injury, why the case isn't moot and so forth, then I'll worry. So you should be looking during that argument, that first set of arguments, you should be looking for questions about standing, mootness, ripeness, all of the justiciability doctrines. If they don't ask those questions, I think they're gonna hold the case. The second thing is, I'll be interested to know how they ask this question, and also what the answer is, which is, I think we'll get questions asking for a limiting principle, that there will be a temptation maybe to as the justice's office often do, which I find really annoying, is turn the case into another case by asking hypothetical questions, often that are just fanciful and honestly kind of stupid. I think they'll do that. And I think that shows where the justices are in terms of thinking, not just about this case, but what else could this agency, they clearly don't trust, what else could they do if given this authority?
Okay, and I'll just say, folks interested, I agree with all the things that both James and Lisa said you should listen to, and I certainly agree with the assessment that the Chief Justice and Justice Barrett are likely the swing votes in this case, especially because some of the other justices, I think, have telegraphed in prior cases how they think either about the major questions doctrine, or in the case of some of the justices, what they think about EPA regulation of greenhouse gases. Because I believe both Alito and Thomas are on record repeatedly saying that they believe Massachusetts versus EPA was a mistake. But thank you all for joining us. I'm about to put the slide up that has the CLE information. The link is in the chat. Please join me giving a virtual or remote thank you to Professor Lisa Heinzerling and Professor James Coleman for being with us this afternoon. I think this has been a very informative discussion, and I hope you agree, and certainly hope you will join us for future programs. So Thank you, everybody. Stay safe and stay well, and we look forward to seeing you in the future.
Thanks for having us, Jonathan.
Thank you so much.